How y'all doing? How y'all doing? How y'all doing out here today? I want to talk to y'all about something that, you know, I want us to understand as black people that we have never been a part of America in the way that you think we have been as equal citizens. In no part of American history have the laws been directed to treat us fairly. So when you hear the Republican Party talk about that they are the party of law and order, when you hear Trump say he is the party of law and order, and I want you to understand law and order and justice are not simultaneously linked. They're not necessarily the same. Slavery was legal, unjust, but legal, the law of the land. So someone abiding by the law would capture a slave, return him into slavery. A just man would not participate in slavery, would oppose slavery, would help slaves escape. He would be considered lawless, but he would be considered just. And I want you to understand this is America's perception of us. This is the Dred Scott case. And the reason why I bring this up, people say, oh, that's an old case. In legal definition, when a case is won and it ruled upon and the courts issued a decision, that is considered law, good law, until it is overruled. This is why when you fighting cases in courts and you are fighting the case, you find a case that suits your argument, but what you have to do second is shepherdize the case. Shepherdizing the case is where you look the case up, see if it's been overruled, the case that you found. So if it hasn't been overruled, that means it's standing law. That's why when I used to file in court, if I find something to be standing law and all my case issues are not questioned, I file a writ mandamus instead of a habeas corpus, meaning this is the law and enforce it. That's what I used to do when I was locked up. But now, this is the Dred Scott decision, formerly Dred Scott versus John F.A. Sanford legal case in which the U.S. Supreme Court on March 6, 1857 ruled 7-2 that a slave, Dred Scott, who had resided in a free state and territory where slavery was prohibited, was not thereby entitled to his freedom. The African Americans were not and could never be citizens of the United States. This never been overruled. Let me say that again. Dred Scott decision, formerly Dred Scott versus Johnson F.A. Sanford legal case in which the U.S. Supreme Court on March 6, 1857 ruled 7-2 that a slave, Dred Scott, who had raised in a free state and territory where slavery was prohibited, was not thereby entitled to his freedom. That African Americans were not and could never be citizens of the United States, and that the Missouri Compromise 1820, which had declared free all territories west of Missouri and north of latitude 3630, was unconstitutional. The decision added fuel to the sectional controversy and pushed the country closer to civil war. Among constitutional scholars, Scott versus Stanford is widely considered the worst decision ever rendered by the Supreme Court. It has been cited in particular as most egregious examples in the court's history of wrongly imposing a judicial solution on a political problem. A later Chief Justice Charles Evans Hughes formally characterized the decision as the court's greatest self-inflicted wound. Dred Scott is an example of why it is imperative that you get on Joe Biden about adding to the courts. When Trump put in, he got 6 conservative members in courts right now. He pushed through 3 on the Supreme Court. This is why it's imperative. Rulings such as this, Dred Scott. Dred Scott was a slave who was owned by John Emerson of Missouri in 1833. Emerson undertook a series of moves as part of his services in the U.S. military. Now understand, Missouri was a free state. Missouri was a free state. What did it say to that? Let's go back here now. Which had declared free all territories west of Missouri. So, okay. Still had a slave there, though. Okay. Emerson undertook a series of moves as part of the services in the U.S. military. He took Scott from Missouri, a slave state, to, Illinois, a free state, and finally into the Wisconsin territories, a free territory. During this period, Scott met and married Harriet Robertson, who became part of the Emerson household. Emerson married in 1838, and in the early 1840s, he and his wife returned with the Scotts to Missouri, where Emerson died in 1843. Now, what I want you to pay attention to right here is that the North was not too opposed to slavery, the treatment or the mistreatment of the human beings, because he took the slaves, these black people, to multiple states and maintained their enslavement, right? You can only do that is if you was allowed to apply violent, aggressive force to these individuals, right? You had to be allowed by the system to legally restrain, beat, in order to keep these people to being slaves. Because clearly he did not want to be a slave. He filed the lawsuit. So what was allowed in Wisconsin, in Illinois, that kept him in servitude to this individual? What was it that he couldn't run off from his enslavement while he was in a free state, right? 2 free states that he couldn't run off. This is where you got to think. This is where you got to understand that means the white people in the North helped reinforce his confinement, his enslavement to that white man. It's clear he wanted freedom. He filed a lawsuit. He got means to get to the court to file a case. That white man couldn't keep him enslaved by himself. So know that the Civil War had nothing to do with the morality or the immorality of slavery. The Civil War was strictly because the white Northerners did not want slaves up north because it would prevent them from being able to get jobs. See, that's the part they ain't going to tell you, that the Civil War and the issue with slavery was an economic issue between poor white Northerners, right? Wealthy Southern farm owners, and the price fighting and the wages paid with the industries in the North. That was the Civil War was about. We black people was a tool used to help the North win the war. Lincoln said after the war was fighting, you can look this up, I will free the slaves in the rebellious states. All the states was not rebellion. All the slave states were not rebellion. He also said, if I could save the Union without freeing one slave, I would. So, okay. Scott Lee reportedly attempted to purchase his freedom from Emerson widow, who refused to sell in 1846 with the help of anti-slavery lawyers. Harriet and Dred Scott filed individual lawsuits for their freedom in Missouri State Court in St. Louis on the ground that their residence in a free state and a free territory had freed them from the bonds of slavery. It was later agreed that only Dred case would move forward. The decision in that case would apply to Harriet's case as well. Although the case was long thought to have been unusual, historians later demonstrated that several hundred suits for freedom were filed by or on behalf of slaves in the decade before the Civil War. You see that? Several hundred slaves filed lawsuits for freedom. This is why who was in the court systems matter so much. This is the significance of that court system, because it's not an indicator of right or wrong. The legal system, as black people all know, has been a system of oppression. That's why your biggest oppressor has continuously talked to you about law and order until it no longer suits his needs. See, I can talk to you about law and order as long as I can always adjust the law to fit my needs. Scott and Emerson took years to be resolved. In 1850, the state declared Scott free, but the verdict was reversed in 1852 by the Missouri Supreme Court, which thereby individuated Missouri long-standing doctrines of once free, always free. Emerson widow then left Missouri and gave control of her late husband's estate to her brother, John F.A. Stanford. You see how how hateful these people is. This woman didn't even need this dude. This is how hateful these people is. She wouldn't let him buy his freedom. This is how hateful these people. These white people are still here today. These are the same white people who smile in your face a lot of times too. Of New York State. His last name was later incorrectly spelled Stanford on court doctrines. Because Stanford was not subject to suit in Missouri, Scott lawyers filed a suit against him in U.S. District Federal Courts, which found in Stanford's favor. The case eventually reached the U.S. Supreme Court, which announced its decision in March 1857, 2 days after the inauguration of President James Buchanan. Chief Justice Roger Brooke tyrant opinion for the court was arguably the worst he ever wrote. He ignored precedents, distorted history, imposed a rigor rather than a flexible construction of the Constitution, ignored specific grants of power in the Constitution, and tortured meanings out of others. More obscure clauses. His logics on the citizenship issue was perhaps the worst, the most cavalcade. He admitted that African Americans could be citizens of a particular state and that they might even be able to vote, as they in fact did in some states. But he argued that state citizenship had nothing to do with national citizenship, and that African citizens could not sue in federal court because they could not be citizens of the United States. Scott's suit, therefore, should have been dismissed for lack of jurisdiction by the district court. On this point, however, Tony stood on shaky constitutional ground. If even one state considered an African American a citizen, then the Constitution required that all states, and by inference also the federal government, had to accord that person all privileges and immunities of citizens. In the several states, Article 5, Section 2, which includes the rights to sue in federal court. Furthermore, Article 3, which establishes the jurisdiction of the federal court, does not mention national citizenship, but rather declares that the jurisdictional power shall extend, among other things, to controversies between citizens of different states, the so-called diversity jurisdiction. Even with this weak argument, Tannery could have been accused of nothing worse than faulty reasoning. If he had stopped there, if Scott was not a U.S. citizen, he could not sue in federal court, and the case would therefore have been improbably granted. But Taney was determined to impose a jurisdictional solution on the slavery controversy. Although later courts would adopt this policy of deciding constitutional questions on the narrowest possible grounds. This is why he put in 200 federal judges. The pre-Civil War courts often decided all issues that could support their rulings. Thus, Taney continued holding that Scott had never been free and that Congress had in fact exceeded its authorities in the Missouri Compromise because it had no power to forbid or abolish slavery in the territories. The Missouri Compromise, which had served as the accepted constitutional settlement for nearly 4 decades, thus failed. Even the doctrine of popular sovereignty, as articulated in the Kansas-Nebraska Act, 1854, whereby the people of each federal territory would have the power to decide whether the territory would enter the Union as a free or a slave state, lacked constitutional legitimacy. Accordingly to Taney, he thus voided the principle of free soil. Opposition to slavery in the territory and in newly admitted states, territorial sovereignty, and indeed every aspect of anti-slavery constitutional thoughts. Regarding the question of Scott's freedom, Tannery held that Scott could not claim to be free on the basis of his residence in Illinois or Wisconsin. Whatever status Scott might have had while in a free state or territory, he argued, once he had returned to Missouri, his status depended entirely on local law, notwithstanding the doctrines of once free, always free. Tannery would have been on reasonably strong ground had he limited himself to upholding the district court's decision based on the ideas that status was to be determined by the state. Alternatively, he could have held that Scott was not entitled to sue Stanford in federal court on the basis of diversity of jurisdiction, because Missouri did not allow even free African Americans to be citizens. But Tannery outraged much of the North by asserting that African Americans could never be citizens of the United States. The farmers, in his view, did not regard African Americans as being among the people for whose benefits and protections the new government was founded, notwithstanding the perfectly general language of the Declaration of Independence and of the preemptible of the Constitution. You see, I want y'all to understand what was just said there. He said that white people never intended for black people to receive the benefits in which of this government. That's what he just stated in the Dred Scott case. Wake up, black people.